Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
Hello everybody, welcome to LawPod. I am Luke Moffett. I am a lecturer in the School of Law, and today we're lucky to be joined by Elisa Novic from Avocats Sans Frontières, and we're going to be speaking today about victim participation at national trials for international crimes. Can you maybe, as an introduction, just tell us a bit more about yourself and ASF?
Yeah, sure. Thanks for having me to start with. I work for Avocats Sans Frontières, which acronym is ASF. It's a Brussels-based organization which was established in 1992. So the mandate is very broadly to promote access to justice and human rights among vulnerable societies. So essentially in the South, as we say. So we have field offices in Africa as well as projects in Indonesia. There, I work more specifically on the topics of transitional justice and business and human rights, which leads me to be more involved with countries like Uganda, the DRC, the Central African Republic, and also Tunisia.
Okay. Elisa, you've been presenting today on victim participation in national trials for international crimes. Can you maybe talk a little bit more about the experience of ASF and yourself and working in this area, in particular in Uganda and Central African Republic?
Yeah, sure. So, in general, at ASF, we really work, we have a really field perspective on any kind of topic on which we work. So we really work at the local level and the national level. So in Uganda, it means working rather around the International Crimes Division within the High Court, and in the Central African Republic, working around all the proceedings related to international crimes. So mostly with the newly established Special Criminal Court and as well at the domestic level. In these countries, we do different things depending first on the needs and also on the procedures. Obviously, there's a lot of work which is related to advocacy for making sure that victims get effective and meaningful participation in the proceedings. And even, for instance, that the principles of reparation are going to be acknowledged in the law and eventually enforced. But we also work very much with actors in this context, trying to first analyze what are their needs and trying to strengthen their capacities too. So we will, for example, do a lot of training for lawyers on topics related to these proceedings, which are quite special in the context. Dealing with international crimes and sometimes with issues which are completely unknown. For instance, victims' participation in Uganda is a very foreign concept. So these are the kind of things we do, but we also work with the final beneficiaries, let's say, who will be the victims, trying to make sure that they get relevant information and that their voice is really heard as well by all the other actors involved, yeah.
Yeah, and is there almost like a tension then with legal professionals and judges when you got like in the common law system is not familiar, as you said, in Uganda versus in Central African Republic where you got the partie civile? Is it easier to engage people in CAR to adopt this procedure, or at least explain to other lawyers or get them involved?
Yes, I'd say yes, because it's at least the concept is known. Then even in CAR, civil party representation will require quite a lot of delivering lots of training as well as to until where we can go also as well in a civil party system, because it's not always that all the facets of these procedures are well, let's say, mastered by those who should be using them, and also because the rules are not always very clearly established. But for sure, it's going to be easier than in Uganda, where everything is new and has to be implemented for the first time. So unfortunately, it's like trials where we would like to say that there is not a right to do mistakes, but it's not like the process will go very smoothly. Obviously, there's a lot of obstacles on the way. So in Uganda, there is a lot of work of really trying to make sure that the concepts are integrated and appropriated by the actors, and not just that they are here because they were in an agreement, they were like in some rules which have been drafted at higher levels.
Yeah. I suppose with Central African Republic, Uganda, and also the DRC, these are also situations before the International Criminal Court where there are other victims who are participating. So the issue of complementarity here is how far should states be including victim participation in these sort of national trial processes? Does it make a difference in terms of the quality of justice, or is it more about sort of copycat of the ICC, that the ICC is sort of setting up these standards and it's like the best practice is to follow or at least mirror what the ICC is doing? So that's a difficult question.
Well, it's maybe it's quite difficult to answer. I think it will really depend. That the idea of victims' participation has been really influenced by the ICC is clearly something we see everywhere. Indeed, because we are in systems based on complementarity, there's a lot of rules which had to be integrated in these systems to reflect what was in the Rome Statute. And victim participation is clearly one. And even in contexts like in the DRC, for instance, where you have a tradition of victim participation through a civil party system, it's still not necessarily let's say the rights are not necessarily very strong either for the victims. For instance, in the DRC, there is no possibility for the civil parties as such to trigger the proceeding. They really have to rely on the prosecutor to do the investigation and to trigger proceedings, which is not that strong. So yeah, you have a lot of influence from the ICC, and on paper, let's say positive influence, because let's say we can assume that effective participation of victims is something desirable. Then if victim participation at the ICC is not necessarily very clear either. Lots of principles are established on a case-by-case basis when it comes to representation, but also to participation. It's very much the judges at the different stages who will decide what are the rights, what the victims can do, and so on and so forth. And to some extent, we see it's also sometimes a bit complicated to kind of establish what are the best practices in this relation and what should be done at the local level when things are not that clear at the ICC level. And again, at the local level, you don't necessarily have very clear rules for everything. So there's always a lot of margin left to the different legal actors that are involved. And this really has to be, it's a gap which really has to be filled on a case-by-case basis, and also making sure that there will be some actors who will be able to promote the right principles in the right place.
Yeah. I suppose also with you've got these domestic trials going on, and you've been engaging and visiting these countries. What do you see as sort of the key challenges in making this work in practice?
There's unfortunately a lot of key challenges, I'd say. In the talk earlier, I really separated the issues into around three main blocks, one being representation, one being actual participation in proceedings, and the other one being reparation. And within each of these blocks, you have very huge challenges. For representation, we are in systems where legal aid is often not available for victims. You might get it for the defense, for the accused, but it might not be that there is a possibility for victims to get legal aid and also judicial assistance. So what if they have to pay a fee to enter into some proceedings, or how do they get access to a lawyer, and a fortiori to a lawyer who will be able to properly represent their interest? So that's really a very, very important challenge. When it comes to participation, again, it's for these lawyers to also be able to navigate through the rules or through the lack of rules sometimes. And here you don't have any kind of principle. It really depends on each context, each tribunal, each actor, let's say. But the issue of, for instance, accessing a court is also an issue. We are dealing with countries which are quite vast sometimes, So it's not that the victims can go where the trial is supposed to happen. So in the DRC, there's been this practice now of dealing a lot with mobile courts to make sure that the courts are also getting closer to the beneficiaries. In Uganda as well, now the trial is happening in Gulu, the hearing in the trial phase. But in Central African Republic, which is a context which is extremely insecure, and the conflict is still going on in most parts of the country, there's going to be like a big challenge in terms of having accessibility to the court in Bangui, and let's say to the courts, because there's more than the special criminal court as well. And finally, for reparation, the biggest challenge is to have reparation effect like actually happening in the end. So it's first having the principle recognized, but it's making sure that if it's ordered, it's like adequate preparation. So it means listening to what the victims want, which is not always the case, and then having them enforced. And we are dealing with accused which are often found indigent, and states are not necessarily willing or able to pay compensation that have been ordered. So that's a lot of challenges that we see in this context here.
No, it's big challenges. We were in Uganda in July there, and we've been there in the last few years, but I remember stumbling into the court in Gulu in 2011 in July, and Kailo was making his first appearance, and there was a band outside, and there was like a whole procession, and it was almost like a ceremony, and you had this difference between the courtroom being very small and packed full of like NGOs, civil society, diplomats, journalists, and there's victims then trying to peek in through the door to see this. It was almost like a circus that was happening. Like so many people were brought together, and yet we're 7 years down the road, and like even when we try to go back July this year, one of the judges had enough petrol in his car to get to the actual proceedings. The bail hearing is only starting to be heard. There's already been African court, or the African Commission has already ruled that he's been denied his fair trial rights and ordered compensation against him, and also ordered that he should have an amnesty. And there's been this whole ping-pong back between the Supreme Court, Constitutional Court, in Uganda itself, trying to work out this whole amnesty issue. I suppose it's frustrating for the victims that from engaging with them, one of them said, I prefer to be a victim in the Ogwen case at the ICC than the Coelho, because at least at the ICC, we've got lawyers who've got legal aid, and even if there's no money with the accused, at least the trust fund will give some sort of reparations, where with the International Crimes Division in Uganda, there hasn't been that much thought about how it's going to be funded. And I suppose it's the frustration that legally we've made these sort of jurisdictional lines where different victims fall into, but in reality, these victims might have suffered the same harm, such as like being abducted as a child, sexual violence, murder. So it can seem somewhat arbitrary in terms of how we frame justice. It's not really a question; it's more of a comment about the challenges of doing complementarity.
Yeah.
And you mentioned in your talk about it's almost like this two-tiered system we're trying to create around international crimes. For victims, how does that sort of feel on the ground when they're engaging with these sort of processes?
Yeah, I think we really have also the same observations as you do. We hear a lot that yes, the victims, they would like to rather be victim in the Ongwen case than in the Koyelo case. And it's been 8 years and not much has happened. Charges just got confirmed and even just got translated for the accused, which took some time. So there's a lot of fatigue on the part of the victims, because a lot of hopes has been raised in relation to this 1 or 2 trials, even if we take the Ongwen case, but their life has not really changed much, or not at all, and still they're very much solicited all the time about this trial. So frustration is really essential here. Like, it's something which should not be underestimated in this trial. And we did this report like last year, which is A Beggar Has No Choice, and that A Beggar Has No Choice was a quote. It's like, at some point, like, what the victims want, can they really tell what they want? Will they really have a word to say in what they want? Will they ever get something? So, like, we also face here the issue, if we want to maybe open the analysis to the scope of the analysis to also include the ICC, that there is very limited complementarity in the end. Complementarity was okay. tribunal was established with procedures which meet like quite high standards in terms of fair trial standards and victims' participation again. But when it comes to what victims can expect as justice and reparation is definitely something that they expect. Here there is no complementarity anymore. So this is also something which has to be taken into account, like really not overlooked in the process. And for now, it's also the court is, as you say, like working with very limited resources for its day-to-day operations and very much reacting on an ad hoc basis to a lot of issues that arise. For instance, how do we register victims? And so it's also difficult to go as far as to anticipate the reparation phase for this court with such limited capacities. But that's going to be quite key in terms of if we want to speak of success, even though I think it's not necessarily the best concept for this kind of processes either. So, yeah, I think...
Yeah, that's very comprehensive. I think, the ICC and the issue of complementarity has suffered from being maybe schizophrenic in the sense that on the one hand it's trying to ensure that trials happen, it ends impunity and holds those people to account, but on the other hand it's trying to incorporate sort of principles that come about in human rights law and the other obligations that states have, particularly around trying to ensure investigations, prosecutions, but also in remedies for victims. And I always think that it's a bit of a concern that when the ICC comes in the country, it was there since 2004 in Uganda, then pulled out in 2014 when nothing was happening, there's nobody been arrested. Dominic Ogwin is arrested in January 2015 in Car, and then the interest comes back. Donors are keen to fund the ICD. There's a greater focus on like transitional justice. I suppose it's that sort of debate about the role of the ICC in transitional justice. Is it sort of framing how we deal with the past and how we deal with these international crimes, that we create a sort of focus on perpetrators, and in that we're framing how we think about different crimes in the past. Like with Coelho, it's in 1996 Pabo, which is just up the road from Gula. It's not too far away, but he's been charged under like quite antiquated laws, like the 1960 Geneva Conventions Act in Uganda, rather than sort of the International Crimes Act, where you've got codified war crimes rather than just how the Uganda was trying to incorporate the Geneva Conventions. That how we think of the past is in quite narrow legal terms compared to broader human rights obligations, but also transitional justice, that there's very little space for civil society to say, we need to speak about broader processes. In Uganda, we need a truth commission. We need a body to start looking after the children, the tens of thousands of children and adults who have been abducted, or even just like issues like land reform after the conflict, after people were displaced from their homes and put into like protected villages. So I suppose the challenge I always find with complementarity is it a way of sort of narrowly framing how we think of dealing with the past. And I suppose it's difficult for a civil society actor. How do you sort of navigate that when you're dealing with victims, on quite an intimate basis? Like you're working to try and empower them, explain to them human rights, but within a criminal law framework.
Yeah, I think like before, like seeing how we navigate, it just like it's also the sad reality that transitional justice has become very much focused on international criminal justice, so like already like a scope which is very restricted, and in the end it's always very resource driven, so we think first of the resources before thinking of the objectives. And I mean, when it comes to Uganda, it's difficult to blame like the court for that because they just don't have much, like a lot of resources. So then obviously it's how you're going to get creative with what you have, but there's a maximum that one can do with this kind of resources. And here you can jump to the issue of like the donor community as well, because they also very much orientate the priorities with what they are like willing to fund and at which moment. And you have sometimes like also change in time, as you just mentioned, from the ICC to the ICD. So it's very difficult to navigate because there's not a lot of elements that we can actually like really on which we have a lot of influence. So like advocacy has its limits because like it's already a process which has been going on for like almost a decade. And like there's always, like for instance in Uganda, like the issue of the adoption of the transitional justice strategy. But that's also like, that's one point. And then you'll have, okay, we will inform the victim, we will make sure that they are like still in the loop, but you can't keep going on like during 8 years on the ground to say, oh, not much has happened, we're sorry. So there's a lot of, we can navigate, but there's some limits to which I think all actors face. But here, what might be important for societies like in Uganda, but also in Central African Republic, is I think really coordination with actors. Among actors, because from the moment we're dealing with limited resources, this is impacting every actor of the chain, not only the institutional actors, but also the civil society side, the NGOs, and so on and so forth. And here it's very important that there is like a common strategy among actors so that they will be able at least to use these limited resources in a very at least to optimize the use of these very limited resources. So that's what we're trying to do in Uganda. And the last few months, I think it really showed that we can go a step further than what we've managed to do maybe in the last couple of years. But yeah, with some limits, obviously,
Yeah. I suppose one of the big issues when you're starting to talk about Central African Republic is obviously the Bemba case. And the special court supposed to capture, just beyond the 2002-2003 violence to like the spate of violence more recently. You mentioned in your talk that sort of, and there now, but like in Uganda, you've had 8 years of victims participating and seeing no reparations. Is it sort of frustrating then that they go through this process and they're maybe not left better off, or they're left worse off? I'm just thinking of the the Bemba case at the ICC, that you had a long-winded process that was engaging victims a lot and trying to shape that. The reparations policy that was going to come forward to the court, but then he was acquitted a few months ago. I suppose you mentioned your talk about the issue of expectations of victims, that you go through these processes. Complementarity is just a way of ending impunity. But at the end of the day, should we just be thinking broader than just criminal processes in terms of we need to have other bodies established so that if criminal trials do fall apart, there's this like a safety net? So you mentioned like reparations, that we need to start thinking about it in terms of complementarity. Can I ask, where's your thinking going in that? Is it like, are we thinking about using, such as the Bemba, the sort of victim applications or decisions before that being used in domestic courts as a basis for like civil reparations, or with the special court, is there any thoughts of how that would work as partie civile, that if there isn't enough evidence to suggest criminal responsibility, can it then fall back on civil responsibility?
That's going to be... I mean, the management of victims' expectations, I think, has been a great issue, but not only in our context, like in all transitional justice context. I don't know, like when the proceedings start, like if like really anyone could anticipate that a trial could last for 10 years or so, then appeals for in the end having someone not found guilty, which is fair because it's a principle of criminal law. So it's that's somehow fair in terms of procedure, but this is not a normal criminal procedure. That's something where you have thousands of victims behind waiting for something. And you can always manage victims' expectations, but I think there will always be like an assumption beforehand that they will get something out of a trial, at least some kind of a truth or a conviction. So this is maybe the first part to what you just say. Yeah, this is something which I think all the international community or even like civil society, all the actors need to be a bit more aware in terms of sort of like the length of procedure and like the final impact of conviction or not a conviction. But then comes very much the issue of complementarity between different mechanisms. And unfortunately, again, in this context where we are, you often only have these criminal justice mechanisms, and which focus on a very limited number of perpetrators, which is also normal, but it means that it leaves a lot of people outside the scope of these proceedings, or because they have to be related to the conviction of the accused. And here, yes, I think we have to think a bit more in terms of as where else we can get reparation. So civil tribunals can be one one avenue for that. But we see in the DRC, for instance, that it's not necessarily like, even if there is rights, even if there are procedures, it's not necessarily working that there are reparations ordered in the end, or not ordered, but enforced, implemented, because they are ordered. So it's really like the issue of trying to get even something more mechanisms of administrative reparation is one. But then this is like, when we were talking about limited resources, this is clearly like an aspect which requires a lot of resources and a lot of commitment, and from the state, which we don't necessarily have in these countries again. We tend to forget like all these commitments which had been taken originally about truth and reconciliation commissions, not meaning that a truth and reconciliation commission is the solution to every conflict and everywhere, and maybe more research, more data are needed to see what would be the role of these commissions in these societies as well. For instance, in the Central African Republic, which is a country which has non-conflict and coup like for how many decades, like. So there are lots of questions to raise, but we have to be careful to not just like limit ourselves to what we have, even though it's difficult to try to be creative in this context where there is not that much political space either. So, yeah.
Yeah.
Can't tell much more.
I think we've focused on some of the challenges, maybe some of the negatives of this sort of approach. Maybe is to sort of round it out towards the end, is to maybe think of some of the positive aspects of this sort of work. That I think when you look at other transitional societies where they've achieved stuff in terms of like truth, justice and reparations and guarantees of non-repetition, is that victims are quite central in that sort of struggle, that nothing gets done without victims advocating, whether politically, legally. What do you see the benefits then of as roles of the organisations like ASF in terms of, you know, building capacity with organisations and these institutions, as well as representing and working with victims?
I think there are positive effects, but which still maybe need to be at some point measured or really assessed properly if we want to get back into a more academic or scientific approach. But in the end, there's a lot of work which has been done around these trials. And in the talk, I say we should be careful to not create a two-tiered system, meaning that we just focus our resources on a very limited legal bubble, let's say, because we only focus on these mechanisms and on the persons who are involved, on the actors involved, and at the same time, it's countries which face much broader challenges, also in terms of legal system, in terms of judiciary, or also non-judiciary, because justice has also like different meanings and different avenues. But I still think that the capacities that are built, if the work is done in like also with a broader purpose of like trying to build capacities at a broader level in these legal systems, then you can have like positive repercussions in the sense that these actors, what they get, they will be able to use it in different contexts. But it's also a matter of creating opportunities for them to be able to use these skills or these tools in different legal contexts. So this means, for instance, for us to not only work with judicial institutions, with the judiciary, but very much trying to rely on alternative dispute resolution mechanisms, not necessarily for international crimes, because there's a lot of discussion on this, but in general, like seeing what works in this society and see how we can make connections also with the more like formal legal actors. And this sometimes will be the same people as the ones who are involved in this context now of international criminal justice. So again, it's difficult to say in terms of like measuring like how the capacities that are built are actually used beyond the initial objective. But I don't think it's vain, especially in these systems where, as you say, a lot come from the civil society.
Yeah. So in a way, this sort of work lends itself to like social and legal transformation. That's you got countries like the Central African Republic where 15 years ago that it was saying, the judges were referring to the International Criminal Court saying we're unable to sort of prosecute these cases, to now in 2018 to be saying we're starting to develop our own capacity and ability to sort of prosecute these cases and think about these issues more broadly as a country, as society. And similarly in Uganda, that these issues are important and need to still be dealt with, and we need to include victims in that process.
Yeah, and in the Central African Republic, I think right now it's one of the major challenges. Like, there is the Special Criminal Court, but it can't be that only the Special Criminal Court is going to be developed in this country. And I think the Special Criminal Court itself is very aware of this, that every development which goes towards this court also have positive repercussions on the rest of the judiciary, especially like the criminal justice system, but not only. And for instance, if you look at legal aid, that's one of the things which is extremely important, that yes, there will be legal aid, quite a sophisticated system for sure at the Special Criminal Court level. It cannot be that it's only at the Special Criminal Court system. It has to foster the development of a much broader legal aid system, which is a big issue in the Central African Republic. And again, when it comes to the victims, at some point, it's really what we call legal empowerment, making them in a capacity to act and also maybe to not only be victims, but also be a citizen and being able to act for a lot of different matters in their life, not only about war crimes or crimes against humanity, but just a lot of other disputes or issues they may face in their day-to-day life. So yeah, it's the kind of perspective that we always need to keep also on all the sides of the process here.
Yeah, that's great. Thanks so much, Elisa, for joining us today on LawPod. And if you're interested in reading more about this topic, please check out the show notes after today's broadcast. And if you're interested in the work of ASF and Elisa's work, check out their website and their current operations in Africa and Indonesia. Thank you very much for listening, and for Elisa for joining us.
Thank you.